Checking 1, 2, 3, 4, 5. We got it. Perfect. If anyone needs a white balance, I got my best read on those paper towels back there. It's closest I could get. I'm at like 4,200 right now. Oh, you're all good. I found paper towels.
Hey, Joe, I'm up on Final Pack again. Can you try to record for Worrell's response to Rose's presser? Yeah. Yep. 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 Cool. Sorry. All the questions.
Everyone phrase it just a little bit different.
Hey, I saw your text. You guys got me? All good? Awesome. Cool. Thanks so much.
Good question. If you're soft, how do you respond?
gonna want them displayed?
I would send it as a folder, or send them to me as separate items in a folder, and she's gonna have to like click through them.
Dave, is Sam sending you something?
Yes.
You put it on there? Can I ask you if you're going to have Sure. She was on the screen too. You want to she's on there? Okay. She was supposed to be, was it Susie that I said last? Sure. She's right. She's, what do you say? So basically, Okay. Hi everyone, we'll be driving for
Yes.
and that and then Leslie. Did they send it to you?
Would someone mind give another mic check just to be safe before you go in?
Nobody sent, wait a minute, what are you gonna,
Mic check 1, mic check 2.
She wanted to have it on the screen.
Yeah.
So,
I'm
so
waiting for her to send it to her.
Okay, so you could put privacy on.
There it is.
Hey Dave,
Yep.
you got it?
Yep. I mean, they're PDFs, so like she's gonna have to like actually scroll through it and stuff. You know, like I can't.
Can you, yeah, you can
It's not
take
like a
some.
PowerPoint or anything. This is how it's gonna be displayed. Let's see how.
That's fine. I saw it, like, they weren't, it wasn't a PowerPoint.
Just making sure I click. So I make sure I like literally click through pages.
No, she just needs you to stay, can you rotate that one?
Yes, just a second.
Just stand here and, help her, like, you might have to do that. Ready? Yeah, don't go anywhere, she said.
I think so.
they have AG components to get on the
So, I guess you can't go on.
I don't know. Okay. Did you get the mic check you needed?
Yes.
Okay.
I mean, there's 4 different documents. I kind of need to know what she's referring to when she refers to it. I can't guess. It's 4 separate things. I have this, I got this, I got this, I got this.
That's fine. Just keep looking out.
Okay.
Okay. As long as they're there.
You want me to leave it on the PowerPoint for now, so you
Yeah.
would do that?
Leave it on top. Okay. All right. So you can introduce yourself. Are you want to? You want to? You want me to? Yes. Okay. You need an introduction? Yeah. Okay. I'll just get it. Thank you.
Good morning. Well, this morning we are here to talk about the increase in road rage in the Central Florida area. Central Florida's population continues to grow, and with it grows the traffic on our roadways. More cars and heavier traffic increase the likelihood of conflicts, and too often these minor disputes escalate into road rage incidents. A decade ago, this wasn't a conversation that we were having at this level, but today road rage has become a serious public safety issue, and in some cases, a matter of life and death. Now, the primary reason for today's press conference was to educate the public about this public safety issue. As state attorney, it is my duty to make sure that our community is safe and aware of the risks that are facing us. This is me doing my job and keeping families informed and protecting our communities. However, just a few minutes before this press conference, the Attorney General sent another letter to my office, the office that I have been reelected to, and multiple letters of this type have been sent seeming to undermine my office rather than to support the work that we do to protect the public. The Attorney General's lack of experience in prosecuting cases and understanding criminal law is dangerous, not just to the public, but to the work my office is doing every day to ensure safety and justice. It is an outright reckless disregard for the truth to suggest that I have non-prosecution policies on the books. These claimed policies simply do not exist and are made to mislead the public and distract from the real work of keeping our communities safe. Instead of communicating directly with my office about concerns or collaborating on solutions, the Attorney General continues to only reach out through press conferences and threatening letters that are sent moments before these press conferences, using them as a platform for political attacks rather than for meaningful dialogue about the public safety of this community. His repeated press conferences spread misinformation and prioritize politics over public safety. Instead of working with us to address crime, he creates division and distraction. He's accused me of incompetence and malfeasance, yet his actions reflect the very behavior that he claims to condemn. The public deserves truth and facts, not misleading statements. I want to highlight for you once again, the Attorney General has zero prosecutorial or criminal practice experience, yet he continues to opine on the decisions that the prosecutors in this office make every single day. The prosecutors in this office work tirelessly to protect our communities. They investigate and prosecute complex cases. They hold offenders accountable, support victims, and ensure justice is administered fairly and in accordance with the law. It is their dedication that keeps families safe, upholds the integrity of our on the people of Orange and Osceola counties, protecting families, holding offenders accountable, and ensuring that justice is carried out fairly and transparently. Public safety must come first, and I will do the work that I was elected twice to do, putting the protection of our communities above political gamesmanship. It is clear that the Attorney General's goal is to take me out of this seat. He is willing to make reckless and untrue statements to the public to achieve this goal. Not only are his actions in reckless disregard for the truth, they are irresponsible and demonstrate his ineptitude to hold the position of Attorney General. You might remember that there was a press conference held by the Attorney General where he criticized me over a case he claimed was handled too leniently by the state attorney's office over in Orlando, suggesting this was evidence of the dangers that can be out there when you have people who want to go soft on crime, which was ironically the theme again of his press conference this morning. However, after reviewing the public records surrounding that case, our office confirmed that none of the defendants that were referenced by the Attorney General in that press conference had any cases that came out of the Ninth Judicial Circuit. In fact, the case that he cited, Frankie Pinheiro, was out of the Fifth Judicial Circuit in Lake County, where he was sentenced to a 20-year prison sentence that was suspended and given 2 years community control. This demonstrates that his attacks were factually inaccurate and politically motivated because he never corrected himself and he never made those leniency statements about the state attorney's office over in the Fifth Judicial Circuit. Similarly, the cases that the Attorney General spoke of today, he gave you inaccurate facts. So I'll go over those briefly because I think that facts matter. In fact, if you've been following me for some time, you know that the very theme of my administration is that facts matter. Because after all, if you can't depend on the state attorney's office to get facts right, then certainly our justice system is in great peril. So in one of the cases, the Attorney General discussed this morning, there was a case where an individual was alleged to be masturbating in public. And the Attorney General talked about the fact that this was an egregious offense, and I agree, it is egregious. The problem, however, in this case is that the Attorney General in his letter would lead you to believe that of the thousands of cases that come into this office on a daily basis, that I personally review each and every single one of them and make a charging decision as to the case. And that is, again, factually inaccurate, and he either doesn't know or doesn't understand the process of how a state attorney's office works, or again, he just has a reckless disregard for the truth. I will leave it to the public to decide which one it is. However, in that case, there weren't any charges brought, and I'm going to show you the case notes from the attorney who handled that case, who happens to be here with me today. And I want to be very clear. I did not have any personal knowledge about this case, but it took me 5 minutes to read the case notes that were well written by the attorney who was assigned to the case to understand what had actually happened in this case. So I'm going to share those notes with you today. It's important because I have asked my attorneys to be very, very specific in their case notes so that in the event that I have to discuss a case publicly, that I can go to those notes and find out exactly what happened. So in these notes, you'll find that first, going back to August the 18th, the attorney did extensive research on what he needed in order to prove this case successfully beyond a reasonable doubt. So that was back in August, and you'll see there that he cites cases, the cases that he researched, that would show him exactly what he needed in order to prove this case beyond a reasonable doubt. Now, I didn't make up those cases. Those cases were there. If you look at the citations on them, they're 1991 and 1992 cases. So this is before I was ever state attorney, before the attorney general was ever appointed to be attorney general. This is case law, which we as attorneys, practicing lawyers, use as a guidepost on how we go forward on cases. So after my attorney did his job and did the research on what he needed to prove the case, on September the 17th, he said he spoke to the victim's father about what happened and the facts of the case. Because as I told you, facts matter. He confirmed that the child did not see anything and wasn't aware of what was happening. He explained that based on the language of the statute, he could not charge the charge of exhibition, which would have been the felony in the case. And he also explained that because no other adult saw the defendant's penis, that he could not charge any of the misdemeanor crimes of exposure. He explained that the victim's father was upset, but he left the 45-minute conversation feeling that the victim's father understood why he could not go further. Now listen, we can't uphold the law and not uphold the law. We can't go forward on charges that the law prohibits us from pursuing. And I would submit to you this morning that although they did a great dog and pony show of telling you that they're going to do my job if I won't do it, if they go forward on these charges, they are not upholding the law, because the law is very clear and I didn't write it. So that's the case involving the masturbation. All things that are wrong are not illegal. And I'm not standing before you today telling you that what happened in that park was wrong. But I am standing before you today telling you that I trust the word of the attorney who was assigned to this case when he said, although those actions were wrong, he could not prove beyond a reasonable doubt that they were illegal. And that is the only standard by which we go forward in prosecution. Now, I want to talk to you about the second case, because this case, the comments that were made in this case would actually be considered defamation if I were not an elected official. When I received the Attorney General's email as he was taking the stage to have a press conference about this case, again, within 5 minutes, my executive assistant provided me with information that this case had actually been transferred to the Office of Statewide Prosecution. Now, the Attorney General wants you to believe that they took the case because we weren't doing our jobs. But I want to take you through the timeline of how this actually took place so that you can understand how dishonest the comments that were made today by the Attorney General and his starting lineup actually were. So what you're going to see here is a notice of prosecuting authority. And this notice of prosecuting authority was filed, you'll see the date up there, on June 10th of 2025. That is the date that it was entered into the system. And this notice of prosecuting authority was filed by the Office of Statewide Prosecution. Now, this is a notice that happens within the normal course of business, so this isn't anything that's out of the norm. And the reason that the Office of Statewide Prosecution would file this is to let us know that the offenses are multi-jurisdictional. meaning that these things happened in places other than the Ninth Judicial Circuit. And when cases happen in multiple jurisdictions, the Office of the Statewide Prosecutor has jurisdiction to prosecute those cases. Guys, listen, it's intricate for those who don't operate in the system. It is. But for people who do this work every day, we understand that this is what happens. We have forms that you fill out. We don't have to create any of this from scratch. We do this so often that there is a form in which the case will populate and the language is already there, because we do this every day as a normal course of business. So again, either the Attorney General doesn't understand the work that we do here, or he just has a reckless disregard for providing you all with the truth. In any event, on June the 10th, the Office of Statewide Prosecution provided us with a notice of prosecuting authority. On July the 8th, the Office of Statewide Prosecution, yes, this one, filed their information in this case. On July the 8th, the Office of Statewide Prosecution filed their information in this case. You will see all the different counts here. There are 8 counts of possession of child pornography, possession of child pornography. Is there a second page to this?
There's not.
Okay.
Oh, I'm sorry. Yes, it is.
Okay. You'll see there are 12 counts of possession of child pornography in this case, filed by the Office of Statewide Prosecution. For the public who may not know or understand, that is a separate entity from my office. The Office of Statewide Prosecution handles cases when our office doesn't. So on July the 8th, the Office of Statewide Prosecution filed 12 counts in this case. Thereafter, on July the 10th, my office closed out the case in our office. So again, it is dishonest and disingenuous for the Attorney General to get up there and say that we dropped the charges in this case. The Office of Statewide Prosecution notified us that they were going to be taking the case over, and after they filed the information, which is their charging document, we closed out the case in our office. This is the normal course of business. It is the normal way that things are done. The Attorney General's behavior would be laughable if the consequences weren't so serious. His leadership is what happens when arrogance meets incompetence, a spectacle unfit for serious times. He struts and shouts as if volume can mask ignorance, but all he's proven is that he's a punchline in a job that demands serious leadership. He continues to prove to be unserious about the responsibility he holds to protect Floridians. He has turned what should be serious public service into a circus act, loud, clumsy, and entirely devoid of substance. Every time he speaks, he reminds us that volume is not the same as vision, and chaos is not the same as leadership. These are the consequences when people are not elected based on their experience, but rather are appointed based on their relationships. It is clear that the underlying intention here is to unjustly remove me from office yet again. This morning, I am providing for you a track record of threatening letters that have been sent to me from either the governor's office or the Attorney General's office since I have been back in office. But as I have said here to you today, my sole focus is on doing the work of the people of the Ninth Judicial Circuit, and every single time I have to stop that work to respond to another circus show held by the Attorney General. It disrupts the work of the men and women here in this office. It undermines the work of the men and women here in this office. And as I've continued to say, you cannot support law enforcement and fail to support this office, no matter who holds the seat and how you feel about them. Questions?
Has your office attempted to reach out to the AG's office and said, come to us if you have questions about what's happening in these cases?
You will see multiple opportunities in there where we have responded to the Attorney General's office, correcting them on some misinformation that they have used as the basis for a threat.
What's your message for the public who might be watching both press conferences today?
One press conference is based on facts, and the other one is based solely upon a political agenda.
The child pornography case that was transferred out of your office, are you aware if it's still ongoing?
It is still ongoing. It is absolutely still ongoing, which is why it's baffling to me that the statewide prosecutor would take the stage and speak of the case as though he was not aware of the history of this case being transferred from our office to theirs. Not because we weren't prosecuting it properly, but because there was multi-jurisdictional offenses committed therein.
How do you break the cycle here?
You all break the cycle by electing people who actually care about people more than they care about politics.
You mentioned that this specific case was handled by a different attorney. You had not prior knowledge of this case. Is it common practice? This is something that happens?
Absolutely. So I am a rare state attorney in that I do prosecute cases, but like one or two, not the volume of thousands of cases that comes through this office on an annual basis. So again, either the Attorney General doesn't understand the inner workings of a state attorney's office, particularly one of this size here in Central Florida, serving a jurisdiction of nearly 2 million people. Certainly, I don't have personal knowledge of every case that comes into this building. So to say, as I am aware, I wasn't aware. I became aware very quickly when my executive assistant pulled the cases and I was able to read the case file. And I would recommend that before you go out and publicly accuse someone of doing something, that you at least take the time to do your due diligence by researching the actual facts of the case and the law. Since you are, I don't know, the Attorney General, you should probably be familiar with the law on how decisions are made.
Is there a way for your office to quantify how much time and resources you've had to put into combating these claims on top of the caseload you already have?
Far too much time. I will have to go back and look at every press conference. I will tell you this one was easier to pull together because we already had you all coming based on a different issue. But hours and hours of time, typically at least an entire day, if not more, goes into combating these responses. Because what I want is this. In the event that I am removed, I need everyone to know what went into that removal. Political agenda and the target, which is Central Florida, by people who cannot stand the fact that there is Democratic leadership in this area.
Do you believe that?
Back to the time when I was removed last time, it was surrounding the governor's presidential campaign. And he needed to score points among his base by actually be elected. So he keeps coming here, he keeps coming here, he keeps coming here, and he has these press conferences that Don't elect a guy willing to take the time to research the facts. I've been an attorney for 25 years, and I have practiced criminal law for that entire time. And I do that, then he really should be quiet, because his ignorance